Good morning, Chief Justice, and may it please the court. My name is Adrienne Shepard, and I and my co-counsel Ali Shakur represent Mr. Joseph Jordan in this case. Mr. Jordan is before this court on an appeal from the lower court's denial of his initial 3.851 motion and also a separate petition for habeas corpus, both with claims of ineffective assistance of counsel. Your Honors, each criminal defendant is entitled to a fair trial, regardless of the evidence against him or the circumstances of his alleged crime. We are requesting that Mr. Jordan receive a new guilt phase because he did not receive a fair trial in this case due to multiple instances of prosecutorial misconduct, more specifically, 5 improper comments that the prosecutor made during closing arguments in the guilt phase. The prosecutor used his guilt phase closing argument to inject an element of fear and emotion the proposition that defense counsel was to an extent speaking for Mr. Jordan. However, I still don't think it qualifies as an invited comment because he wasn't saying that Mr. Jordan wasn't sorry. Further, even if you could perhaps say this is an invited comment, if defense counsel had gotten up there and said, Mr. Jordan absolutely is sorry, we're still in the guilt phase. And Mr. Jordan's lack of remorse has nothing to do with the issue of his guilt. And it was the prosecutor's role to help the jury understand the relevant evidence at trial and the applicable law in how to determine whether or not he was guilty of first-degree felony murder. His lack of remorse.
But you do acknowledge, I mean, I think you already did, that if counsel got up there and said, my client is so sorry for this, if he tried to play on the sympathies, that would open the door for the prosecutor to point out that exactly what he did. You have 5 letters before you from this defendant, and not once does he say, I'm sorry. I mean, that would be completely permissible if...
I agree that perhaps if defense counsel had said Mr. Jordan is sorry, defense counsel did not say that.
Didn't defense counsel recognize in the evidentiary hearing that, I mean, and I read his testimony as saying that, well, I didn't object to that because I realized that I sort of opened the door for that when I said...
That, yes, Your Honor, yeah. That was trial counsel's testimony at the evidentiary hearing. And I think that actually lends to how deficient he was. He thought that he had opened the door. He thought that he had said, Mr. Jordan, did have remorse and was sorry, when in fact he didn't say that. So he couldn't even remember what his argument was.
So you think it's appropriate for defense counsel to try to garner sympathy with the jury and take their eyes off the real issues by just saying it themselves, knowing that it's going to be attributed to the person that he represents and not saying that my client feels that way? You think that is okay?
Your Honor,
And it wouldn't open the door?
I don't think that that's necessarily proper. I don't think that that's what defense counsel is necessarily trying to do. And I don't think it qualifies as an invited comment. And once again, it's not relevant to whether or not Mr. Jordan was guilty. This was guilt-based closing arguments. Further, there wasn't just one improper comment. We've been talking about the first one. There are 5. And we need to look at the cumulative effect of these comments. And so even if this court were to find that perhaps the comment on the lack of remorse was an invited comment, which it's my position that it wasn't, and it's not relevant to Mr. Jordan's guilt, this court could still find that cumulatively or individually, when we're looking at the 4 other comments, that they still prejudice Mr. Jordan to the extent that he did not receive a fair trial.
And just, you said repeatedly that these are prosecutorial misconduct arguments. Am I correct that they're really ineffective assistance counsel arguments? They're failure to object to these comments, correct?
Yes, Your Honor.
Yeah, because you can't, in a post-conviction relief, argue prosecutorial misconduct because you have to do that on direct appeal, correct?
Yes, Your Honor.
Okay.
Our current claim is an ineffective assistance of counsel claim under Strickland. And moving on to the second improper comment that the prosecutor made, he went on to the first of his 2 golden rule arguments. And I will say that these 2 golden rule arguments were not raised on direct appeal. This is the first time that this court would be considering these. And in his first golden rule argument, the prosecutor graphically described the fear and hopelessness that he even used the word imagined Mr. Cope felt during the incident. And closing argument is not meant to be an exercise in speculation, and the prosecutor got up there and said, I would imagine that Mr. Cope thought this and Mr. Cope thought that. This could not reasonably be inferred from the evidence, and it was absolutely not relevant to the issue of Mr. Jordan's guilt. It violated Victorino v. State, which said that a prosecutor is not supposed to make a golden rule argument where he asks the jurors to place themselves in the position of the victim and imagine the victim's potential defenselessness and hopelessness. And that's what the prosecutor did during that comment. It's clearly improper. And moving on, during his rebuttal closing argument, the prosecutor continued by ridiculing the defense theory that Mr. Jordan snapped during the robbery and may have been in a state of severe emotional distress. Once again, trial counsel failed to object to this comment. And then only a few minutes later in his second golden rule argument, the prosecutor once again asked the jurors to place themselves in Keith Cope's position. And the prosecutor actually said, if you could do that in America, then we'd all be in trouble because the mortgage companies would have us tied to the bed. And what the prosecutor was essentially telling the jury was 2 things. One of them is somewhat of a proper argument. The other one is where it's improper. He's saying that Keith Cope owed Mr. Jordan money, and Mr. Jordan took that debt by force. But then, and this is where the prosecutor is improper, he's saying, imagine if your creditors collected your debts from you in that same way. This is clearly an improper golden rule argument. He's asking the jurors to place themselves in the position of Keith Cope. Imagine if this happened to you. This was completely inflammatory, and it spurred the angers of, it would have made the jurors very angry. And finally, moving on to the 5th improper comment, that once again trial counsel failed to object to all of these comments. The prosecutor concluded by stating, don't let him get away with this. And what the prosecutor was doing in the context of that comment was telling the jurors, you can't find Mr. Jordan guilty of any of the lesser included offenses. You have to find him guilty of the highest offense he is charged with, and the only offense for which capital punishment is possible. And essentially, when we look at the combination of all of these arguments, what the prosecutor was telling the jury boils down to this. Find Mr. Jordan guilty because you are angry. And that is not a proper argument. And this court explained in Berlotti v. State that Closing argument must not be used to inflame the emotions and passions of the jurors to the extent that their guilty verdict reflects an emotional response to the crime and the defendant, as opposed to a rational application of the relevant evidence and applicable law. And in this case, Mr. Jordan's guilty verdict reflects an emotional response to the prosecutor consistently focusing on, impermissibly focusing on, the tragic circumstances of Mr. Cope's passing during guilt-phase closing arguments when he should have been focusing on the evidence as it was relevant to whether or not the state had proved the 3 elements that the jury was instructed on for first-degree felony murder.
Even if error, how do you overcome the Strickland prejudice requirement?
Your Honor, I would say, number one, there's a reasonable probability that if trial counsel had objected to any of these comments and to all of them, that the trial court would have granted a mistrial, and then Mr. Jordan could have had a fair trial in front of a jury that did not hear these comments and were not thinking about these comments when they were deciding the issue of his guilt. Alternatively, if the jury had not heard these improper comments or perhaps had been given some type of curative instruction not to consider them, they could have found Mr. Jordan, they could have reasonably considered the evidence and found Mr. Jordan guilty of one of the lesser included, not first-degree felony murder, but the lesser included charges that they were instructed on. And trial counsel offered no reasonable tactical decision for why he failed to object to these comments. He testified that his defense theory was one of 2 things, either not necessarily to get Mr. Jordan acquitted outright, but to have the jury find him guilty of one of the lesser includeds, or in the alternative, to prepare for what he viewed as a very likely penalty phase. And trial counsel should have recognized the prejudicial and inflammatory effect that these comments were having on the jury. And in fact, what these comments did was they essentially, they made the jury find Mr. Jordan guilty of the only offense that came with the death penalty. And so if anything, trial counsel was going against his defense theory by not attempting to exclude these arguments. And I will save the remainder of my time for rebuttal.
Good morning, and may it please the court. My name is Patrick Bobick, and I represent the state in these cases. The appellant's first claim on appeal is merely an attempt to rebrand a direct appeal issue in the ineffective assistance context. And in fact, this exact claim was made on direct appeal. 3 of the 5 comments before you today were analyzed by this court. The other 2 are very similar to other comments that this court analyzed in that they talked about Keith Cope's final hours. So this has already been decided by this court. The only comment this court found to be improper was the comment, "Don't let him get away with this." Every other comment was found to be meritless. And then this court analyzed this under fundamental error because it was not objected to, and found that there was no fundamental error from this comment. Which leads me to my second point. This court has found in Chandler v. State, which was a 2003 case, that once a claim has been dispensed with in direct appeal under fundamental error, you cannot then succeed on an ineffective assistance claim on post-conviction, which is where we're at now. But if this court does decide to get to each of the 5 comments, I'd also argue that none of them are impermissible. Although I will concede, since this court has already decided that don't let him get away with it.
Let me ask you about one issue that was addressed on direct appeal.
Yes.
The prosecutor said, "I told you it was coming, and there we heard it. It's everybody's fault but the defendant's. I mean, if he had stayed in the middle of the bed, he would still be alive. If these guys had come up from South Florida a day and a half earlier, he'd still be alive. Come on. Everybody's fault but his." I mean, he snapped. Is that a defense? He snapped. Did we determine that that was not denigrating toward the theory of the defense?
That's correct. That's one of the comments that was analyzed by this court, and one of the comments that the court found was meritless on direct appeal.
Did we say it wasn't denigrating, or did we just say that there was no
The
prejudice?
court addressed all 8 together and said there were 8 other prosecutorial comments that were addressed by defendant, and all of them are meritless. So the only comment that was addressed at all was that don't let him get away with this. And the court didn't analyze the other 8.
But meritless in the context of fundamental error.
Right.
No, in that there was no error. The only comment that the court found error with was don't let him get away with this. They said the claims for error on all the other comments was meritless. And that's why there was discussion in fundamental error analysis on just that comment. But my argument would be that there's no deficient performance because these comments weren't objectionable, and even if they were, the trial court below found that the trial counsel's strategy was a sound one. This was a case with overwhelming evidence of guilt. The guilty verdict was a foregone conclusion. They even candidly said that their only hope was the jury would ignore the felony murder rule to avoid a first-degree murder conviction. So he knew that he was preparing for an inevitable penalty phase, and that credibility of the jury was very important. So he says that in those kinds of cases, which this was one, that he has a strategy of not objecting unless the prosecutor goes way over the line, which didn't happen here. And even if this court finds all 5 of these were objectionable and should have been objected to, I think it was pointed out before that you can't find prejudice. And again, that's because of the overwhelming evidence of guilt. He confessed the crime to his friends in Hollywood. He confessed it to 2 different people he stayed with. After he came back, he confessed it in a letter to the victim's ex-wife. He confessed it in a letter and a recorded interview with the police detective. His fingerprints were at the scene. It simply was always going to end in a guilty verdict on first-degree felony murder. And so since there's no deficiency and no prejudice, this claim should be denied. If you have no other questions, I yield the rest of my time and ask that you affirm the circuit court's order and deny the habeas petition.
Can I just go back to the point that Justice Lawson and I asked you about?
Yes.
So I'm looking at, this is a pinpoint page 929, 930 of the opinion. Quote, finally, Jordan raises 8 additional claims of prosecutorial misconduct during closing argument in the guilt phase, one of the ones you're discussing.
Yes.
We find those claims meritless and unpreserved for appellate review. We find also that none of the comments taken individually or cumulatively constitute fundamental error. Accordingly, we deny review for these claims. So you're saying that that statement is a statement of us on the merits?
No, I agree with your reading of that, Judge.
Okay.
But again, in that context, Chandler v. State would then instruct you that because they weren't fundamental error on direct review, that they're not ineffective assistance on post-conviction review.
But back to the one that I was asking you about, why wouldn't that be denigrating? Do you think that that's not denigrating?
I think he gets close to the line, but I think it's a fair comment on the defense. I mean, the defense throughout was trying to reduce his culpability by saying if things had been different, Keith Cope would still be alive.
The defense usually does that. I mean, that's not uncommon.
What?
That's not uncommon.
Yeah. I mean, was his language harsher than absolutely necessary? Yes, but I don't think it rises to the level of denigrating the defense. All right, if there are no further questions, I yield my time.
I'd like to address the point about the fact that we are rebranding the direct appeal issues as a post-conviction issue. First of all, I agree with the statement that once a court has found that something is not fundamental error, that you typically can't prove prejudice under Strickland. However, to your point, Justice Luck, this court did not consider the cumulative effect of the current 5 arguments we are contesting. The 2
3 of them we did, didn't we?
Yes, Your Honor.
So it's just the 2.
Your Honor, I would still argue that when we're looking at the cumulative effect, that when you add our 2 new golden rule arguments, it changes the story that the prosecutor is painting. And I would also go back to Justice Luck's point that this court did not consider the merits. It was a blanket statement that we find them meritless. So I don't think that, even with the Chandler decision and that general proposition, I don't think that the 3 comments that were somewhat decided on direct appeal are barred in this context. Further, those comments on direct appeal were all considered under the very heightened fundamental error standard, and that's because trial counsel was deficient and failed to object.
But you just conceded that if we didn't find fundamental error, we can't find prejudice under Strickland.
I I think if we were, Your Honor, I would agree with that if we were attempting to raise all of the exact same improper arguments that were decided on direct appeal.
You're just raising most of them.
We're raising, of our 5, 3 of them were raised.
So the
on
question
direct
would be whether the addition of the one comment about creditors in America and debtors in America would take it over the edge and make it so that it would undermine our confidence in the outcome.
Yes, Your Honor, I do think that the addition of it's actually 2 golden rule arguments to those 3 previous ones would push it over the edge, and I think that the cumulative effect of the 5 comments that we're currently contesting, including those 2 new comments, like I said, shifts the story. And yes, I think it amounts not only to fundamental error, which is not the standard we're required to meet in this context, but there is a reasonable probability that the cumulative effect of these 5 improper comments affected the verdict. And if trial counsel had been adequate and contemporaneously objected when these comments were made, then this court would have been deciding all of those improper comments on direct appeal under the harmless error standard, which is similar to what we have to prove at this point, that there was no reasonable probability that the comments affected the verdict. However, this court was required to consider it under the fundamental error standard. And that's due to trial counsel's deficiency. So there's clear deficiency here as to that point. To Justice Luck's question about whether or not this court explicitly, or I may be attributing that question to the wrong
We both
justice,
asked it.
but I'm sorry?
We both asked.
Okay, there's a question about whether or not this court explicitly, as far as that comment on denigrating the defense, said that was actually denigrating the defense. This court didn't explicitly make any finding on that comment. Once again, it was a blanket statement. This court this court explicitly considered 2 comments, one that was the only one that trial counsel contemporaneously objected to. That court found it was not error, and then it considered one of the ones that we're currently raising that don't let him get away with this statement, which this court did find was improper. So it's clear that trial counsel was deficient for failing to object to what this court has found to be an improper comment. As to the comment concerning denigrating the defense, this court did not make an explicit finding on whether or not that's what it was, but it's our position that when he gets to the point...
I mean, I don't know that you can assume that just because the comment was improper that it was ineffective assistance not to object in context, particularly that one, because it was sandwiched in between a long, correct explanation of the law that you will have an opportunity, jury, to consider all these lesser included offenses, but the evidence, I would submit, is overwhelming that this charge has been proven beyond a reasonable doubt, and the law requires you to give a verdict for the highest offense that's been proven beyond a reasonable doubt. And then he said it this way: don't let him get away with it, meaning, if you look at it in context, don't follow the law, essentially. And so you wonder if an objection to that one little phrase in the context of an overall wouldn't have brought more attention to it. I mean, I'm just...
Your Honor, I agree with the statement that just because this court finds a comment improper, that doesn't necessarily mean it was deficient to object to it. I think when we're looking at the cumulative effect, that comment, don't let him get away with this, and it is sandwiched inside a long kind of soliloquy about other things, but it is the final of those 5th improper comments. It is the last one. So
well, let me ask, did counsel offer a strategic reason for not objecting there that the trial court credited as making it non-deficient for failing to object?
Yes, Your Honor. Trial counsel testified at the evidentiary hearing that his strategic reason overall for not objecting was to maintain credibility with the jury for the likely penalty phase, and he didn't, I guess, want to draw attention. Your Honor,
And the trial court credited that?
Yes, Your Honor.
Right.
The trial court found that was a reasonable trial strategy. I think that could be a reasonable trial strategy generally. I think when you get to the point where you have this amount of improper comments, and the fact that, as opposing counsel said, there is significant evidence against Mr. Jordan, and trial counsel was preparing for likely penalty
But this
phase.
is not a case where the trial court sat on their hands. In other words, we've had cases where there's no objection at all, and it could more credibly be stated that counsel was asleep at the wheel, but this is not one of those cases, right?
I would say he was nearly asleep at the wheel.
Counsel-
He only made one objection to, one comment, so let's say those are 6 comments, because the one that he objected to was
Right.
certainly improper. He missed the 5 other ones. And he failed to, if he was trying to prepare for what he viewed as a likely penalty phase, he should have recognized that when you're asking the jury to imagine what it feels like to be tied up and left, that's going to make them angry, and that's going to make them think, this guy has been charged.
More accurately, he did not ask the jury to imagine what it felt like to be tied up and left, did he? He used the word imagine one time, as I recall, and he said something and then said, I would imagine, but he wasn't asking the jury to imagine.
Not in that comment.
Right.
There was the other comment with the mortgage companies where, no, he's not saying imagine if you're, but he is, that implication is clear there. So I don't think that the prosecutor is required to explicitly say, feel this or imagine this, but it's clear what he's implying to the jury. And to conclude, Your Honors, trial counsel was deficient for failing to object to the prosecutor's 5 improper closing arguments, and there is a reasonable probability that had trial counsel objected, one of 2 things would have happened. The trial court would have either granted a mistrial, and Mr. Jordan could have had a fair trial in front of an impartial jury, or in the alternative, the jury would not have been so inflamed by these improper comments, and they would have been able to rationally understand the evidence, or rationally consider the evidence, raising reasonable doubt as to Mr. Jordan's guilt, and very likely could have found him guilty of one of the lesser included offenses. So in conclusion, due to these several instances of prosecutorial misconduct, we are requesting that Mr. Jordan be granted a new guilt phase so that he may receive a fair trial. And if there are no further questions?
All right, your time has now expired. We thank you both for your arguments, and court will now stand in recess.
All rise.